AI for Belgium is very pleased to welcome you to this workshop. It's meant to be thought-provoking, and we are pleased that you picked this workshop right before your lunch break. We would explore the right to an effective remedy in a digital world. Does this right does the effective remedy effectively exist, or is it merely artificial? In the next 70 minutes, we invite you to explore an ideal world. Imagine a world where people that are affected by AI know they are affected by AI. Think, for example, when your loan is being calculated, when you're manipulated into voting on a certain candidate, or whether or not a certain advertisement for a job or a housing is shown to you. Imagine that people already know they're affected by an AI or other digital tool, and that they know where to turn to. What institution should they go to if they feel disadvantaged? Imagine a world that they also have the mental and financial capabilities to actually address the harm they incurred, and a world where oversight mechanisms have the necessary technical, financial, and staffing resources. Our three distinguished panel, consisting of the human rights expert Francesca Fanucci, GDPR expert Pierre de Witte, and our enforcement specialist Nicolas Devieux, came together and will discuss these questions today with us. They will put their expertise and imagination together to construct such a world, and we will reflect on what the right of effective remedy actually entails, how it is translated in the current context, share best practices, and discuss limitations. But there is a twist. We cannot do it alone, and we need your brilliant minds and innovative ideas to redefine the boundaries of this legal and institutional landscape. And this we will do during the second part of the workshop. We will discuss a concrete use case under guidance of Karel Morch, member of the Ethics and Law Board of AI for Belgium and director of FARI. And based on some guiding questions that we prepared for you. But first things first, what is AI for Belgium and who am I? AI for Belgium is a coalition of the public, the private sector, academia, civil society, and other relevant stakeholders. I'm not such an impartial bystander, but I would call it a best practice for multi-stakeholder participation in policy making and awareness raising. Recently, with the Ethics and Law Board, this is also the team, the working group that is organizing this workshop, we launched an initiative to develop an ethics charter in the public sector. And you know what came out of the first round of group discussions? The need to be enforceable, the need to have a right to file complaints, etc. And this is why we opted for this topic in this session. I am your moderator for today. My name is Nele Hoekens. I am part of the Ethics and Law Working Group of AI for Belgium, and in my other role, I am legal advisor at UNIA. This is Belgium's equality body and national human rights institution. And at this national human rights institution, which does the oversight for human rights violations, we experience firsthand that the right to effective remedy is far from effective. Of the 10,000 complaints we receive on a yearly basis, the 3 last years, there is only one complaint that was filed by a civilian, an academic nota bene, who reported he thought he had been victim of a negative treatment that was related to AI or a related technology. So I'm honored to steer the conversation today towards exciting discoveries, and I'm looking forward to learn of the panelists and all of you. So let me introduce you to Francesca Fanucci, who will kick off the panel. She is Senior Legal Advisor and works on projects at the United Nations, Council of Europe and EU, where she addresses the impact of new technologies on AI and civic freedoms. She also represents the Conference of International NGOs at the Council of Europe, where they're currently negotiating a convention on AI, human rights, rule of law, and democracy. She's advocating for standards and regulatory frameworks that protect fundamental rights. Some of you might remember her from last year, where she fell backwards at a panel on human rights impact assessments, and she quickly sprang up, stating that the ex-ante obligation for risk assessments should not only be applied in the AI context. And I'm very curious to see how she will demonstrate her point this year, talking about effective remedy. So, Francesca, the right to effective remedy is enshrined in multiple human rights conventions, and it is stated that it must take the form of a guarantee and not merely a mere statement of intent. So this is a consequence of the rule of law, which is a fundamental principle of our democratic societies. These are big words, but what does it practically entail? How is it translated in this current context? How does the AI Act, the Council of Europe Convention, take it into account? The floor is yours.
Thank you. And luckily there is no stage here, but it seems only fitting, and this year I'm talking about right to act, a right of effective remedy, even from falling. But anyway, how do I move? Just press on this button. Ah, okay.
Ah, yeah, I'm sorry. I forgot this.
You want to maybe briefly?
Ah, this is
Okay.
yours.
Okay, so I press the red button.
Yeah. No, the green.
Ah, the green.
Yeah.
Green in the middle or green below? Sorry.
The big green.
Okay. So to be sure that we are all on the same page when we talk about rights of redress, at the cost of sounding a bit pedantic, I wanted to set the scene and start from the very definition. So what do we mean by right of redress? By consensus in on the fora of discussion, but also in the laws and international standards, the right of redress is a right to an effective remedy, and I have highlighted this, when our human rights and fundamental freedoms are either unduly restricted or violated, breached outright. Now, but what is an effective remedy? And of course, this very much depends on the type of violation that we have incurred. So in some cases, you may find that an effective remedy is an inquiry capable of understanding, identifying those responsible and how they managed to undertake that violation. Or it could include an explanation of how something works. We'll see how relevant this is in the case, for example, of AI systems. A correction, for example, when we want our data to be corrected. An apology, that also helps because you may have incurred in the damage to your reputations, for example, so you need a redress in that sense. The right to erasure, we've seen it in the right to be forgotten in the GDPR, so erasure of data information about yourselves. It could be the restoration of online content that was erroneously removed because deemed as illegal, and we have these examples now covered by the Digital Services Act, which we'll see. The reinstatement of the previous situations. You had been affected, for example, you did not receive social services because you were excluded by an AI system and you want to be reinstated into your previous situation. Or compensation of your material or non-material damage, or even more of these altogether, differently combined. Now, who can make sure that this remedy is effectively issued? It could be directly the author of the violation. So in our context of AI, for instance, the provider of the AI systems or the deployer, especially if it's a public authority that imposed it on you. In the Digital Services Act, it could be the online intermediary services that removed, curated your content. Or a trader, someone that you engaged with in a contractual relationship as a consumer in the EU Consumer Directive. Or it could be public authorities, like independent administrative authorities that you address to complain, or the courts, or national human rights institutions, or once again, a combination of all of these. Now, when it comes to the general overarching principles protecting our right of redress in the EU and in Europe, broader Europe, we can refer to the Charter of Fundamental Rights of the EU, where Article 47 protects not only our right to an effective remedy, but also the right to a fair trial. And I've picked out the definitions that interest us in this context. So it acknowledges the right to an effective remedy before a tribunal, and then everyone is entitled to a fair public hearing. So the tribunal has to be independent, impartial, And obviously, as part of an effective redress, everyone shall have the possibility of being advised, defended, and represented. And we will see how important this is later when we talk about our demands for an effective right of redress in the context of AI. The European Convention of Human Rights, the broader overarching instruments to which we are bound and that protects our fundamental rights, in Article 13 establishes that everyone whose rights and freedoms are violated shall have an effective remedy before a national authority. So it goes broader, it doesn't specifically say a tribunal. And even if the violation has been committed by people that acted in their official capacity. Now, if we look more closely into the case law, so the jurisprudence of the European Court of Human Rights, how did they interpret this Article 13? They gave useful indications on what effective remedy actually means. So, for instance, effective means that the remedy must be sufficient and accessible, so the right of access is also entailed here, for the person concerned. There have to be minimum guarantees of promptness, so it's not enough to establish a right of redress that happens in 10 years' time. It has to be sufficiently, adequately prompt. Then it has to be effective in practice as well as in law, so it's not enough to lay it out nicely in a law, it also has to function in practice, and I believe my colleagues here, panelists, will give examples of how harder it can be in practice to enforce this right. And then, obviously, the national authority to which we address can be either a judicial or non-judicial body, but both must be independent. And the non-judicial body, in any case, even if, say, it's an arbiter for an out-of-court settlement, they must have the power to lay down what is a legally binding decision. It's not just a recommendation. It has to be empowered to impose the enforcement of their decision. Excessively restricted requirements may render the remedy ineffective. So if, say, you have to comply with lots of filing impositions or paying fees to address an authority, so ultimately all the obligations, all the criteria for exercising your right must not invalidate the essence of your right. And then, with regard to acts of private person, there has to be a rule that says that the state shares the responsibility for such acts, if only for not having been good enough at preventing them, or not taking enough measures to prevent them from happening, from monitoring for the compliance of the law by private actors. Now, when it comes to the design, the development, and deployment of AI systems, sorry, do you have? Yeah, I don't know if do we take questions right now or at the end, Abina?
As you feel comfortable. In general, more at the end, but if it's a very precise question.
Yeah, no, I was just wondering. Yeah.
Yeah, no, I mean, you just said that it could be a non-judicial body as
Yeah.
well, but then you also said that the body should have the power to hand down legally binding decisions, but then we were talking about arbitration, so I was thinking like, if it is not a legally binding decision, then it is not an effective remedy. Yeah.
Yes, but if you sorry, shout it. If you think when you go into an arbitration, you bind yourself, you enter a contractual agreement in which you bind yourself to the decision. So in that sense, it is legally binding. The law that allows you to choose an out-of-court settlement, for example, must establish that that contract is binding for you. And if you choose to go under an arbiter, you have to accept and comply with their decision. So in that sense, it is also, although it's voluntary, it becomes voluntarily legally binding for you. Thank you. You're welcome. So, when it comes specifically to the design, the development, and use, deployment of AI systems, what are the possible harms that we can incur and the rights that can be violated? And here I've outlined a series of non-exclusive, non-exhaustive examples. One is the being subject to unjustified mass surveillance. typical example, facial recognition cameras that may be set up in the street with the pretext of controlling protests. In fact, they are there every day and they gather data of all people. FRT can be done live, so in real time, but also with post-remote storage of data, which can be checked up later. Then you can be subject to discrimination. I believe we are all aware of the case, very infamous case of Amazon that was using an automated system to sort out the CVs for employment, and it turned out that the system was discriminating against women because historically the data set on which it was trained could detect the trend that more men were considered as fit for the job. So it learned, it assumed that men were better for the job and perpetuated and amplified the discrimination. Or violation of the presumption of innocence and fair rights, because this is typical, particularly in the use of predicting policy systems. So there are systems that are used to predict crime based, for example, on emotion recognition, and they may discriminate certain type of people, or based on answering questions that show that you had previous convictions or that you come from a certain area. So all this perpetuates, but we also saw cases of judiciary in the US that used an automated parole checking system, and it turned out that black people were consistently rejected parole because they were assumed to be more propense to recommit the crime than others. So it also is a case of discrimination as well as violation of the presumption of innocence. Then obviously being subject to incorrect decision in several areas like healthcare, say those systems that are being used to screen patients to decide which patients deserve a fast-track access to the doctor or not, or systems that screen people eligible for social services. Yes, you have a question?
No, sorry, just to mention that you're actually almost out of time. So
sorry. Yeah. I will try and be...
30 seconds to finish the last slide, maybe?
Okay, yeah. So anyway, yeah. I will... there would be so much to discuss, but nevertheless, you have the examples here. I believe we can share the slides afterwards, but you can see now recently and officially the right to a healthy environment has been acknowledged even by the UN, Human Rights Council. So you can also claim that AI systems that use excessive energy or water to cool down the systems, they have an impact on the right to a healthy environment, and all the other rest of civic, political and socioeconomic rights, as well as long-term effects, let's not forget, on our society. So we thought it was only obvious that when the AI Act started being discussed, there would be provision in the proposal that was first issued by the Commission, there would be norms on the right of redress. And then we found in shock that there were none whatsoever. Now, to be fair to them, it's not that they couldn't care less about the right of redress. It's just that their rationale, and they explained it to us, was that you don't need them in this act because they already exist in other acts, like the GDPR, Law Enforcement Directive, anti-discrimination laws. They can all easily apply to AI systems already. But we disagreed, and I'll show you why. So if you take the GDPR and the Law Enforcement Directive, they have parallel provisions, at least on redress. So you can lodge a complaint with the Data Protection Authority if you believe that your data processing breaches the regulation. You can take legal action even against the data controller before an ordinary court. You can take legal action even against the Data Protection Authority if you don't think it handled your complaint correctly. So, and you have a choice of all these options. You can have a full and effective compensation for material and non-material damage. You can, the supervisory authority can impose administrative fine, but you can also, and also you can be represented by public interest non-profit organizations. In some states, the states can even allow not-for-profit organizations with a public interest to lodge a complaint without a direct mandate of the person offended. Having said that, you still have to deal with the processing of personal data. So what happens when the AI system does not process personal data. And I'll give you an example. RoBorder was a project that was funded by Horizon 2020, a fund of the Commission. They spent lots of money on it. It was tested in 2021. It was an automated border surveillance system for checking boats that could have illegal migrants to stop them from even approaching the coast. So they were using, I won't go into details, but using several sensors to detect the presence of the boat, but also to detect via heat waves the presence of human people and human activities inside. Now, they were not processing personal data of people, so they were not infringing their data protection, data privacy. But obviously, by identifying the boats and stopping them from even approaching, they would deny the possibility for these people to apply for asylum. And that was their right protected by human rights. So this is a typical case in which the GDPR would not apply, but an AI system does have an impact on human rights of people, discriminates among people inside. Some may be eligible for asylum, some may not, and yet they wouldn't have right of access under this law. Then obviously the GDPR allows, in Article 22, applies only to solely automated decisions. What is a solely automated decision? It's a decision made exclusively by the machine. So what's the role of the human? Is it enough to, what about semi-automated decision? I realize I'm trying to shorten, but
Maybe
now,
we can indeed,
yeah.
I can come back to the GDPR and maybe we can just go to the final slide.
I'll just go quickly to, so essentially, even the Digital Services Act, it presents some very interesting provisions on redress, but essentially, ultimately, it applies only to AI systems used by online intermediary services, so a very specific sector. The EU anti-discrimination laws, they are not enough either, because if you think about it, and I invite you, when you receive the slides, to look into this study commissioned by the Council of Europe, a body on anti-discrimination, they only focus on protected categories of discrimination, so by race, by gender ethnicity, by color, but the AI systems sometimes create their own categories for discrimination. If you think of online shopping, which discriminates people, discriminates the price applicable to people.
I'm really sorry. I could discuss 1 hour about discrimination, but we need to move forward.
So, we, our demands, and this is where I can conclude, for the AI Act to include a comprehensive right and redress framework with the right to complain to the national authority, judicial redress. We want qualified national not-for-profit organizations to be able to represent them, even without a mandate, but even for collective interest, to be able to identify societal risks. And then we want it to be complemented by right of access, transparency, and the possibility of having fundamental rights impact assessment with the consultation of stakeholders. And we would like to applaud the recent report approved by Parliament, which includes some of our demands, but unfortunately, it still does not include the right to be represented by not-for-profit organizations or the rights to act without mandate to flag even societal risks, and the fact that it recognizes the consumer's relationship and the application of the Consumers Directive, but not all LLI subjects are consumers linked by a contractual relationship. So that was, and I'm sorry it took longer than time, but I'm happy to go back into some details afterwards. Thank you.
Thank you, Francesca. I'm really sorry for cutting you short. This only demonstrates that we have a lot to discuss, and this right entails a lot. I'm happy you ended with a positive note, and now we have a little bit more an idea about the technical, theoretical, legal framework. I would like to invite Pierre to the stand, who will give us a more practical application. He is a doctoral researcher at the Leuven University Center for IT and IP since 2007, where he conducts interdisciplinary research on privacy engineering, smart cities, and algorithmic transparency. But he doesn't stay at his desk all the time. He applies his knowledge regularly into practice. He has filed multiple complaints before the Belgian DPA, including the one against AIB Europe, together with Johnny Ryan, Jeff Oslos, and several NGOs, which is currently pending before the Court of Justice of the European Union. Pierre, may I ask you to take the stand and give us some of your insights?
Yes. Thank you very much for the introduction, Nele, and thank you very much, Francesca, for laying, I think, the groundwork for what I want to discuss with you today. So the idea I basically want to discuss with you today was like reporting on all the issues and all the obstacles that we face with another co-complainant when we try to step up and exercise and enforce our rights under the GDPR against the provider of a chatbot application. So you might have heard recently in Belgium the case of a suicide of like an individual who basically interacted with a companion AI app for a couple of months, and unfortunately it did not really end well because it was an emotional dependency created basically by the chatbot provider. So what we really wanted to try as a form of exercise was going after the provider of the chatbots and try to exercise our rights under the GDPR to try to see what we could do against it. I'm not disclosing the name of the chatbot or the provider because we're still waiting now on a decision on the admissibility of the complaints before the APD. But as soon as this is admitted, and we have high hopes that it will be admitted, we will put online a model complaint explaining our reasoning as well for people who are interested. So again, the idea here is really to walk you through the kind of decisions and the kind of obstacles that you will have to face when you're actually trying to enforce the GDPR. And the first thing that you will have to decide is basically whether you would want to go for a judicial remedy before courts and tribunals, or whether you want to go for an administrative remedy, so going after a provider against, like basically before a DPA. And there are actually three factors at least that will need to be taken into account when you're making that decision. The first one being the cost. Because of course, if you decide to go before the judicial, you will inevitably need to be represented by a lawyer. So that's a major factor that you need to consider, while in theory only because I also come back to that later, filing a complaint against a controller at the DPA is basically free of charge. There was a requirement from the GDPR and an essential requirement from an effective remedy as well. But that's just theory, and I will mention that a bit later on as well. The second factor that you need to take into account is basically the type of outputs that you as an individual expect. So were you hurt or damaged, and are you seeking compensation for that damage? Because if that's the case, you will need to go to the judicial, so before a court or a tribunal, because it's not in the competence of the DPA to award any kind of compensation for damages that you might have suffered. So that might not be the way to go for you. And the last element, I think, is the degree of complexity of your complaint, which is essentially nearly always present and very high in case involving AI systems. And that's the reason why I think you should also consider the fact that judicial authorities here in Belgium are, in my opinion and from my experience, not really comfortable yet with very technical and very complex issues involving AI system. So DPAs might be the best way to go for you if it's really complex. That's the first decision that you have to make. Now, the second decision that you will have to make is which processing activities you will go after for which, and basically conducted by which provider. So that's the metaphor of lasagna that I like to use sometimes, especially with students. When it comes to very complex processing operation, it is very often the case that you have multiple layers of processing operation that are basically taken care of by different chefs, so to say, so different controllers. So the way you decide to circumscribe the exact processing operation that you want to go after is going to have a major impact on how you direct your complaint and all the infringements that you basically try to enforce against the provider. So in our case, in the case of the chatbot, we essentially had two options. The first option that we had was to go after the entity that has basically trained the large language model that was then later used by the chatbot provider, and it was entity A, which we didn't do because, again, we had another idea in mind. And the other option that we decided to go for was to go after the provider of the chatbot, using the large language model to then provide that to individuals in the context of chatbot, and they could then tweak the functioning of the chatbot depending on user preferences, for instance. And this is really something that we wanted to go after because this is what creates the risk of emotional dependency and potential kids, for instance, using them for heavily sexualized erotic roleplay kind of stuff, which we've noticed a lot in practice when it comes to chatbots. And maybe also creating discrimination and harm, inciting to hatred towards certain communities. So all these issues, we wanted to address them through the lens of the GDPR. But for that, we really need to decide on which processing operation we wanted to address. The third decision that you will have to make, so now that you know whether you're going for the judicial or administrative remedy, now that you know which kind of processing operation you will go after, is to decide basically what kind of infringements you will bring forward. Because in our case, it would have been really easy to just mention the fact that their privacy policy was crap, which is the case to this date as well. But then the fix is also very easy for them. Just go to a consultancy firm and have like the privacy policy fix and call it a day. This is really not something that we wanted to address. We wanted to have like deep fundamental impact on the functioning of the chatbot and how these risks are being taken into account. So the way we did it was by basically combining the objective of the GDPR in Article 1, Paragraph 2, together with the entire narrative on data protection by design and accountability in 5.2, 24.1, 25.1, to argue that basically chatbot providers, in case they are a controller, in case they process personal data, are responsible for taking appropriate measures, technical and organizational, to basically make sure that all data subjects' fundamental rights, including but not limited to privacy and data protection. This is really, really the point that we wanted to emphasize, must be basically complied with. You need to make sure that these rights and freedoms are mitigated, all the risks are mitigated, which is the core narrative that we try to develop in this complaint. That's going to be the last word as well. Inevitably, any kind of enforcement action, and I know that from my own experience as well, is very likely to take you a lot of time, and is certainly likely to take you a bunch of money as well. Here I've tried to list all the potential steps that might be triggered by you sending a complaint against the Belgian DPA or any kind of DPA here in Europe. I've not listed them all. I'm pretty certain that I've forgotten extra steps as well. And the final decision on appeal, which is like the last point, is certainly not the last final word, because you can always appeal, for instance, and go for the Supreme Court. But in essence, this is what it entails for you if you decide to enforce and meaningfully enforce your rights. Giving an example of another complaint in which I'm also a party, the IAB complaints, also pending here in Europe and now at the Court of Justice, the initial complaint was sent on the 26th of June 2019, and we are now at the stage of the request for a preliminary ruling at CJEU, and this was filed on the 19th of September 2022. So that's quite a substantial amount of time, and we were extra lucky to have a law firm representing us, that we had policy making on our side, that we also had a lobby for digital rights on our side as well, so it was really fast. So if you compare that to the decision of Meta that we had on Monday, it took 10 years, and it's just the decision, the administrative decision, not even the appeal. So that's something that, of course, will depend on the case, But in our case, we were quite lucky, but still, that's quite some time elapsed between the complaint and the decision. I mentioned the monetary aspect as well, which is very relevant, because some of these steps, even though you launched an administrative proceeding which is free of charge, they still involve the judiciary. So, for instance, in Belgium, we had a decision on the use of language, because, of course, Belgium, and we have 3 languages, and we need to agree on how to use them. And the decision of the APD, we basically disagreed with it. And then we had to go to the Court of Appeal here in Belgium, the Market Court. This was a judicial remedy that we had to take, so we needed lawyers. We appealed, we cross-appealed basically the decision from the APD, also before the judicial, so also need to be represented by lawyers. The request for a preliminary ruling at CJEU required some very, very specialized and technical knowledge from counseling and dedicated counseling, specialized counseling, for which, of course, we needed to be provided with some funding. So the monetary issue is very, very prevalent in case you decide to do something meaningful. There are many, many, many more issues really that I could talk about, including the fact that we had absolutely no way of knowing what was happening at the DPA, no way of knowing whether they had contact with the Irish DPC, for instance, whether there was any kind of deadline that they could basically try to follow. The use of language was a mess. I think it's not only the case in Belgium, but for any country that has multiple language in administrative proceedings. The status of the parties, for instance, when it comes to the sanction, we had absolutely no access to the sanction form that was dictated by the APD. So again, we could not contest any of the findings from the APD when it comes to the monetary fine. There are many, many more issues, as I said, and I would really like to point out to 2 very important documents, I think, because if you would like to know more about the procedural hurdles that you might face. The first is really like an excellent report piloted by Access Now and written by a bunch of excellent scholars from the Data Protection Law Scholars Network, called The Right to Lodge a Data Protection Complaint. Okay, but then what? I think it's really important to read it. And also a bit weirder, so to say, but NOIP's answer to the public consultation launched by the European Commission on the potential harmonization for the procedural rules surrounding enforcement. Also very important, they listed 70 issues that they face in all their complaints. They had more than 800, I think, pending complaints at the moment, so they really have a good experience. And also, the DRNDEF's Commissioner for Justice yesterday announced that the actual regulation, new regulation supplementing the GDPR when it comes to procedural rules is going to be proposed in the next couple of weeks. So this is going to be an additional regulation to the GDPR surrounding exactly that, procedural rules. So I think it came a bit earlier than I anticipated, but that remains to be seen. So that's also something that we'll have to take into account, of course. And yeah, with that, I think I could discuss that in more details with you in case you have like more precise questions on the enforcement, but I'll leave it at that for the sake of time, Nele. So,
thank you. Perfect.
Voilà.
Thank you so much. That was definitely enlightening, very practical, and I'm curious to hear Francesca's take if he took us through the timeline and how that responds to the requirement of promptness for effective remedy. But before...
And in effectiveness in law and in practice.
Indeed. But before we dive into that and discuss this with all of you, I would like to hand the floor to... Sorry, this is... Pierre finished actually before the timer. I would like to hand the floor to Nicolas. Nicolas Defieux. Nicolas Defieux is director of PEREN. He will explain you a little bit more on what PEREN is. But what I can tell you is that he has an economic background and almost 20 years of experience in oversight and enforcement. I told you earlier that I'm not so impartial when it comes to AI for Belgium, but as regards to PEREN, I am impartial, and I can tell you, at least from my point of view, an oversight mechanism for human rights violations. I think this is an inspiring best practice, and I would like your attention for his presentation. Thank you.
Hello, everyone. So I will have a slightly different angle from the question about the effective remedy. Because to have an effective remedy, you need a regulator or a judge that's up to the task. And in the context of AI, that might be difficult. So that's what PEREN is about. So PEREN is a government service that is there to provide state-of-the-art expertise for all the regulators out there. It's a pretty recent administration. I mean, we were created in August 2020. And the reason behind the creation of PEREN are the questions that are listed here. So it's all the challenges that we know we face when we have to deal with the regulation of digital platforms and giants like Meta, Google, or the likes. There are strong asymmetries in the technical field. Dealing with AI, all those new technologies, is something that is very new and very complex, and the regulators usually don't have this type of culture. One other reason behind the creation of PEREN is we had the feeling that all the really smart students were just dreaming of going to a big tech platform. So that's where they would think they would learn the best practices and know and do stuff that is state of the art. And they were not coming to the public service because the image of the public service is more outdated, I would say. Another thing is that, of course, France wanted to play a strong role in the field of digital regulation, and also consolidate the dialogue between the government and the platforms, because usually it's a discussion between PR people and lawyers, maybe, I would say, and so the technicalities of the reality of how the systems works are maybe not always on the table. And another objective was the coordination of the public action on a technical level, because you have lots of regulators, you have lots of fields of action, but technically it's more alike than it looks. So that was all the objectives, and so PEREN was created in 2020, as I said. We started working and building stuff in 2021. And then we had our legal framework that was consolidated in 2022, but it's again being updated. I will tell more about this. So the size of the team is 25 people, who seems maybe small, but compared to some research labs, it's already significant. What the key point of this here is that you only have technical and digital science experts. You don't have any economists, you don't have any lawyers, you only have technical people who do code and do AI. It's not that they learn about AI, but it's that they are able to actually implement and do it. And all the keywords that you see in the cloud here are not like just therefore because it's nice, it's actual fields of expertise of people on the team. And so the main point I wanted to stress is that we are here to empower regulators, but we are not a regulator. So PEREN doesn't have any legal, doesn't impose obligations. We just build tools, we talk with regulators, and we provide tools for them. And the kind of thing that we do is like actual code, actual AI programming. It can be analysis. It can be also what we call regulation back office. Like for instance, you have all the discussions about the AI Act. It's sometimes useful to go back to the experts and actually ask whether what is written makes sense or can be implemented in a non-ambiguous way. And we are also a sector facilitator in the sense that when there is a discrepancy or when there is a dead end in a discussion, it's always easier to go back to the technical stuff. As I said, we help all the administrations in France that deal with platform regulations, and that is quite a lot. So here you can see that you have like different bubbles. You have the red corner where we have the independent administrative authorities, like privacy protection, like transportation, social relation, electronic communication, the future digital services coordinator, the competition authority. All these bodies at some point will require to monitor obligations for a digital platform. And they will have to deal with algorithms, with data, with AI, and they need to be helped. You have on the other side the government ministries. The three in squares are the three actual bosses of PEREN, meaning that we work for everyone, but at some point, if we don't have the resources to help everyone, choices need to be made, and you have those three who have like a special vote to say, okay, the emphasis will be there, and this will be a priority, and this won't be. But we work with, of course, the digital ministry culture, which is involved for everything about press and the DSA, Ministry of Economics, also Foreign Affairs for everything that's related to the efforts to tamper with terrorism on platforms, housing, the Ministry of Interior. So all this are French administrations. We also work directly with the European Commission, the DG Competition and the DG Connect. And also recently, I don't know if you've seen the Joint Research Center from the Commission inaugurated a new center called the European Center for Algorithmic Transparency. And this is like the, I would say the equivalent of PEREN at the EU level, and we work directly with them. The only difference is that the ECAT works only for the implementation of the DSA, whereas we work with all regulators as long as there is digital platforms involved. And the last corner I haven't mentioned yet is, of course, academics, because if you want to be state of the art, you don't build everything yourself. You ask the people who actually know and are like at the forefront of everything, and so we work a lot with research institutions. So this is mutualization, but it's also very, very specialized in the sense as, for instance, if I take the field of natural language processing, which is a field of AI, it makes, we have specialists for this, but it wouldn't make sense to have a specialist for this specific field in every regulator. So they would not be able to access this kind of expertise just by recruiting for themselves, because they don't have enough subjects to occupy and make happy an NLP specialist. But if you mutualize everything, then there is enough work for those people. And also we think that if you put 1 or 2 or 3 data scientists or computer science experts in every authority, they will be able to do stuff, but they won't progress or enrich themselves and do more as if you put like 20 or 25 in the same space and then there is like some more emulation between them. Some examples of achievements quickly. So this is an example of what we call black box auditing. The black box only means that you don't have access to anything from the platform. It's some kind of an adversarial approach. So you just send requests and you analyze all the answers you get from the algorithm. And from this, you determine how the algorithm works. With this kind of approach, you cannot do perfect explanation of every single decision made by an algorithm. You can be wrong for specific cases. So this is not suitable for explaining an individual decision made by an AI. But it will answer a lot of other questions that are relevant for in other contexts, like self-preferencing or the platform to business regulation, where a platform has to disclose and be transparent and say what kind of variables it uses to rank results or to promote stuff. And so with this here in this example, which is about food delivery, you can see what are the variables that are automatically detected as being used without accessing anything from the platform itself. This is very interesting because we can also assess with certainty almost, or with a degree of certainty, if the list of variables that are used is exhaustive or not, which is an obligation. Another type of subject is this. It's the detection of characterization of viral content. Again, it's using AI to understand how the AI of the platform works, so it's a kind of a game. And here, what was interesting about this subject is we tried and we looked at what the publication from academics were. And this is a very interesting subject because the idea behind this is to try to detect viral content or problematic content. You can classify it without actually looking at the content itself, nor at who said what. So this is again an example where we try to minimize the personal data that is used to serve an objective of regulation. And there are 100 more projects, so I won't go here. Just 3 things. We tried first to work with the cooperation of the platforms. That didn't work so well. It took a lot of time, and in the end, we had nothing much. So there was a legal framework that was adopted where we now have 3 ways of acting. The first, it's on the right side of the slide, is what we call convention with the regulator. We actually have some kind of a contract, but it's in the law. We work under their authority. So we can go to the privacy protection regulator, to the competition regulator, or to the equality défenseur des droits. And then we work for them and they make all the decisions and we just provide the expertise for technical stuff. The second way of, the second pillar for us is general research, like academics, so that we can have partnerships and publish papers. And the third one is what we call the experimentation power, which is pretty interesting. It's that platforms have an obligation to cooperate with us. We can scrape their content, even if they say that it's illegal, that it's not allowed. For us, we have a legal permission to do this. And final but not final words, just to say that we provide an answer to the technical challenges, but of course not to the legal nor to the standard of proof, which is different from one regulator to the other. So there is still need for better coordination among this. We have the DMA and the DSA, which will provide this, and just to say that we're ready as the DSA will be implemented next September. And that was it.
Thank you
And
so
I'm
much.
truly,
Thank you so much for elaborating on it. I'm sorry that we do not have more time, especially hearing how your legal base and how you provide this technical input to other regulators is interesting. We actually prepared a use case to discuss in 2 different groups, but time is running out. We only have a small 20 minutes before your lunch break, so Karel and I propose to head back to the use case. Sorry, this will take a while, but discuss it in plenary. And there are 3 guiding questions regarding the use case, and we invite you to start with a Q&A, to give comments on the guiding questions, on the use case that you see, your ideas, and we will ask the expert panelists to comment on this. So you can consider it a sort as Q&A combined use case scenario. But, technical assistance are required. How can I? The slides are not going. Okay, sorry. So this was the use case. It's prepared by Karel. It's about a local government that has many requests for housing assistance subsidies, and they hire a private company to automate the attribution process. They develop a tool that processes the request faster, and a family used it and received aid for a year time. The government later thinks that there has been a mistake and subsequently requests complete reimbursement for the entire year. The family decides to sue the local government. They feel it's disproportionate and they are concerned that it might be related to their ethnic origin. This could be a use case in all of our countries. The points that we wanted to draw your attention on and ask your input is how can the family invoke their right to effective remedy, but also how can it address collective or societal harm that might arise in this context? What are the possibilities on the GDPR, or what do you think that new legal solutions could be used? Then existing best practices, if you can share something that you haven't heard during this discussion, that would be most welcome. And thirdly, maybe we can also focus a little bit more on that with the panelists. Pierre already shared a little bit his opinion on the difference between administrative and judiciary redress institutions, but what institution is actually best suited to address the complaints? You see some examples on the slides. Should they cooperate? How do you see it feasible that effective redress is possible for this family? So let's start with a Q&A. Someone feels comfortable to kick off?
I have a question, but not... Actually, it is related to the last question, so I wonder if any of the panelists has an idea whether it's possible to have parallel procedures before different institutions. I mean, for example, Pierre mentioned that whether it is a better idea to go to a DPA or a court, but I don't know if anyone ever tried to do both at the same time, or whether you have an idea if it's possible, or if it's a good idea, or if it will just make it even more complicated. So that's my question.
Do you have a specific panelist in mind to address first?
Actually, this is something Pierre mentioned, but maybe Francesca was also...
You want to go ahead? I can go ahead.
I mean, I can add afterwards if you want.
Thank you so much for
Yeah, I can also maybe already answer. The thing is, again, from my experience, the knowledge of judicial authorities is quite limited. And frankly, when we were at the... I hope there is no representative from the market court, but we really had a hard time, to be honest, like explaining the basic... I really hope there is no one from the market, but we really had a hard time explaining the concept, because even for us, experts, so to say, on the GDPR and on technical issues, it was really difficult to apprehend all these notions. So I believe really that at this stage, at this time, at least in Belgium, so I'm making a lot of disclaimers, it is a bit complicated to go before the judicial. Now, sometimes, not to mention the Irish DPC, DPAs are a bit slow. So there have been cases already when data subjects have decided to specifically go to the judicial to avoid all the problems related to the timing. And I mentioned the fine against Meta that we had on Monday. It took 10 years, plus 3 basically complaints before the judicial against the DPC itself. So imagine a world where you have to go after a DPA because they're too slow. And that's the reason why some people have basically decided to circumvent that thing and go directly to the judicial just because they wanted to avoid all the lengthy procedures. So it does exist, and I think there is a world where you could actually combine both. Now, it's also a fragmentation of regulatory powers, which I think is a bit problematic. Again, going back to the expertise that has been, I mean, it's their bread and butter at DPAs to basically understand the protection law, to have technical expertise, maybe thanks to PEREN, for instance, or similar authorities that can give like a feedback on the technical stuff. They have the competence and they should have the knowledge to do it. So I would rather try to focus on that. But again, in some cases, you might need to dodge the lengthy procedure bullet, so to say. So there is possibility to combine.
Thank you. I can say from the merely legal perspective that at the moment the AI Act envisages that member states should appoint an existing national supervisory authority or create a new national supervisory authority to deal with these cases. And it is in practice obvious that the overall, the majority of states thinks of appointing the existing data protection authorities, because in most cases, not all as we saw, but most cases, AI systems entail processing of data or training on data. But and they consider empowering these organizations, the independent administrative authorities, with more capacity, more staffing, because obviously they will have to deal with more cases. But what we propose is in those countries where there are, at least in those countries where there are powerful national human rights institutions, there could be joint cooperation on these cases. And this is something that already has a precedent, at least on paper, in the GDPR, where Article 60, I believe, says that national supervisory authorities can cooperate with each other. So that could be a solution as well, because these are matters that entail data processing, technicalities, but also impact on human rights, on which the human rights institution may be better versed. So I believe there doesn't have to be a one-size-fits-all solution. It very much depends on the condition of the states. As Pierre mentioned, the DPA in Ireland, for example, is overwhelmed with cases because all the techies are legally based there. So it will depend. But we do see definitely there needs to be a stronger empowerment of national supervisory authorities, stronger involvement of national human rights institutions, and hopefully with organizations like that of Nicola, empowerment, although in a longer term, of judicial courts, at least to refer cases, for example, for access to the algorithm, explainability, to the proper organizations to help them do their jobs as well.
I don't know if this works. Does this work? Yes. I'm making a very off comment, so please don't repeat it after. But I think now the AI subjects, it's a really shiny new toy, and everyone wants a piece of it. And you have a lot of regulators, a lot of administrations that want to be relevant and have a piece of it. So if you go to a regulator now, you have chances that it will be accepted and they will try to do something. But and the only rule, I mean, this will probably take a lot of time, but you have different authorities that will try to do something if they have something in their legal framework. And anyway, there is no problem since there is a non-bis in idem principle, for which that the sanction will never be pronounced twice on the same matter. So I would just say that go for it.
Thank you for all those comments. Does anyone want to add something to this discussion, or maybe have another burning question? Yes, please.
I have a question. I have some questions on the facts of the case, but maybe it's interesting. So my name is Beatriz Botero. I teach law at CENTPO. Why wouldn't we sue? Why wouldn't the local government sue the company instead? If there's a mistake, like why does the burden of the mistake fall on the individual? I would try to bring suit under the contract between the local government and the provider, depending on who designed the algorithm. But I wonder why would I have to carry the burden of a mistake as a citizen? It's different as if when I commit fraud. And I'm curious. And then the other question, now that I'm here, is how do you think this changes with the liability directive that's under discussion? And maybe it's also interesting to discuss here. Thank you. And super interesting presentation.
Which directive?
The liability directive. Thank you.
Thank you for that difficult question.
If I may, well, the liability directive will cover compensation for damages caused. So in that sense, it depends on the type of redress you want, because you could still go to claim your money back from the social services, but then separately sue on the grounds of wanting compensation for the damage that you have suffered in the meantime. So it's a different type of redress and a different type of responsibility. I mean, your question is really good, because it touches upon what it would be interesting to understand, to elaborate more on this case and understand where did the mistake come from. Is it because did the machine, again, automatically, solely decided that that family deserved social services, or did the machine produce a recommendation and it was a human that ultimately decided based on recommendation? And in that case, obviously, lawyers will go wild trying to determine who is responsible, the human or the machine. So, and that will also have impacts on the application of the GDPR or not. But I would say that, I mean, provocatively, I could also reverse your question and say, suppose that the machine or the human supervising the machine made a mistake and gave and actually did not give money to the family. And then 1 year later, they say, oh, we realized we made a mistake. You actually deserved that money. You could claim, why should I receive that money if there was a mistake? You know, the same way, you know, if you claim that there has to be a correction of a situation that was illegal, it works both ways. So it's not because you receive the money, you say, no, it's fine. You know, it's your mistake, your responsibility. I get that money anyway. So, but then again, you are right in that whoever made that mistake should ultimately be held accountable, and the weight should not entirely fall on the family. On the other hand, allow me to add a consideration on the question that you made, that this family should ideally not only sue for themselves for the damage incurred, but also for the societal effect. I find it a bit risky to put that burden on the individual as well, because obviously they would have to prove, they would have to spend money, capacity, and find defense. So I would say that in that case, it would be better if an NGO, an organization, a public interest organization, picked up their case or assisted them, and their role would be to expose at the same time, based on their mandate, the societal risks. So I would say, if that family decides to go down that avenue, they will already be very busy enough to prove the damage made to them and to explain how this happened, access the relevant information to explain how it happened. I would leave it up to even legally to an NGO to be able to address the collective interests, even in support of that individual case, but prove the long-term societal effects.
Okay, maybe just quickly add to that, like, you're very right that the individual has like quite a high burden to like make compliance happen, but also remember that, switching again the discussion to the GDPR, there are a couple of mitigation solutions that are implemented in there. Article 80, paragraph 2. None of the member states have implemented it, which would allow a non-for-profit organization to go directly to the DPA, even without the representation from the data subject. But none of the member states have actually implemented that provision so far. So that's the first element. And second, DPAs can very much start an investigation on their own volition. They can decide, okay, let's open up an investigation against this specific provider, and they are very vigilant when it comes to application and services used by the public sector, for instance. So that's like these two measures exist. And for instance, the fine that we had on Monday against Meta is a fine based on an inquiry on their own volition from the DPC. So it was, let's say, started by data subject, then taken back by the DPC, which is a good and not a good thing at the same time. But these remedies exist. So data subject play a very important role, but they are not the only actors actually trying to enforce. There are other, let's say, safeguards that could potentially apply. GDPR-wise. So I'm not that familiar with the liability directive, disclaimer.
No, but the devil indeed is in the details, because the GDPR says the states may allow MPOs, may establish, but they didn't. Whereas that's why in the AI Act we want to go further. We wanted to say you have to allow MPOs to conduct, and not only in support of individuals offended, but also by flagging up general violations to the regulation.
You want to add something? Yeah. Please go ahead.
No, I mean, yes, thinking out loud, because I also remembered it doesn't say in the use case, but you mentioned something about that the family also thinks that this new decision is based also on their ethnicity. Mm-hmm. Is that still relevant for the discussion? Because
you can build different hypotheses. It's to leave it open and assess different possibilities.
No, because I mean, in that case, I guess for me in my head it's okay, who is damaged here? Is the government damaged because they pay too much? Let's say no. If the damages is on the family side in the sense of we were supposed to get this money for real and now it's not because there's this new element of ethnicity that discriminates against us. But there, I guess there's also this side where you can make the case if that's visible, and here is where I get stuck. Like then how do you build the case that this is a pattern, because it does happen, and a determining factor for not giving the money based on just this, which based on law is illegal, right? So this is why I was stuck at that piece of information that would be interesting. And there again, I think comes together the role of also NGOs that can go out in the field, look for more information, or even, so. Because I mean, for me, I don't understand tech at all. I think I discover something new on my phone every day. But in my mind, it is certain policies that are mediated by technology. So even the question whether it was a tech outcome of a technology or the human, it still starts, I feel like, with the human if it's a certain policy that is being translated into a technologically mediated decision-making process, right? So, yeah, that's a bit my blurs.
I wanted to make a bit of the same comment, so I'm not answering, I'm like adding to the question. It's like implicitly, there is a question of something that's automated in the discussion here, but I wonder what would be the solution if you remove this line. It's just you have exactly the same topic, except that you don't have the provider of an automated attribution process. You just have a local government that received money and received for 1 year, and then the government realizes that they made a mistake, and then requests a complete reimbursement. The family decides to sue the local government. I mean, do we actually know what would happen in this case, like as a counterfactual to the intervention of the AI? And because in many of the questions that are here, it's not really related to the AI.
It's a very relevant remark, and this is, I think, the question that a lot of people that are thinking about this topic are asking themselves every day. Like, do we need new legal tools and instruments, or can we just use what is existing already and apply it to the new situations? But I think Francesca will very well be able to explain why she's of the...
Well,
please explain.
Let's try to break down the case. Imagine that the family, rightly or wrongly, assumes that they have been discriminated the second times because of their ethnicity. They will need to, first of all, they will need to understand who made the decision, the human, or the machine. So is this a solely automated decision-making system or not? If it is, Article 22 applies of the GDPR, so they will have a right to a meaningful explanation. In order to have access to the minimum explanation, they will ask, and the government will go to them or they are similar to access the logic of the algorithm. And then the logic of the algorithm may detect that effectively there are patterns, either that the database is incomplete, so there is not enough representation of a certain ethnic group, and therefore it may be biased in its results, or somehow the machine detects trends that in the past people with a certain ethnicity were denied, so it repeats the pattern. So they prove the discrimination. The problem here is that if the government says, no, the machine only issued a recommendation, and it's a human that made it, but it didn't just rubber stamp. They made actually a proper elaboration. Proof is they made a mistake the first time, and now they thought about it again and said, no, actually, this had to be different. Article 22 doesn't apply. They're stuck. Unless there is specific regulation in the AI Act, for example, that says, no, they still have the right to meaningful. Because all of a sudden that becomes not a solely automated decision-making machine. So
solely automated decisions are better because you're more protected.
No.
No, that's not the point. It's that in the GDPR, you have the right not to consent unless there are certain situations established by law. So obviously, if you are forced to be subject to a solely automated decision-making, you have more safeguards because obviously, for starters, you don't have the right to refuse. So if you don't have the right to refuse to be subject to a completely automated machine, as a minimum, you have the right to contest it. In that sense, yes, it is more protected, but that's what we object. We want protection for all systems that to different extents involve the assistance of an automated machine in the decision-making, even by issuing recommendations. Because let's face it, even if I as a human in an office use a machine to help me, to recommend, if I want to speed up my job, more often than not, I'm just going to follow what the machine says. I'm not going to dispute it.
My counterfactual and my question was not like in the case of assistance, but in the case of no assistance, you're just a human alone on a desk making these decisions by, I don't know, throwing dice or...
No, I'm not questioning.
What we can say is that you clearly touched the right button with this question, and I think maybe Pierre, with his decision tree kind of thinking...
But can I hijack the mic just for one second? It doesn't matter, automated or not. Forget about it. It's really... I don't disagree. I think you're more protected in case it's an automated decision-making because you have extra prerogative. But if you go back to the root of the GDPR, it's the protection of all data subjects' fundamental rights with regard to the processing of the personal data. Nobody cares whether it's an automated decision or not. You're still protected, right? So you have more specialized tools like Article 22 in case it's automated. But you asked how to build a case. It's very easy. Non-discrimination, fundamental right. Still protected under the
Very
GDPR.
easy. I would like to nuance that. I'm trying to build non-discrimination.
The legal
cases,
reasoning
but
is
yeah.
easy and doesn't rely on Article 22, whether it's automated or not. Doesn't really matter, in my opinion. It's still fundamental right and it's still within the scope of GDPR, is what I wanted to highlight.
No. GDPR covers all processing of data, not only automated. But when it comes to automated, there is only Article 22 with these caveats and these flaws that we are trying to correct with the AI Act.
We have asked 7 more minutes from this patient audience from their lunch break. I don't know if you have 30 seconds for each panelist for a final message that you would like to convey, that you want them to take away.
Go ahead, Francesca.
Heat it up.
Sorry, what should I...
You have 30 seconds for one key message that you would like to convey, that you want them to take away from CPDP 23. So the bar is high.
Well, please follow the AI negotiations closely, even on the liability directive, and try to advocate for an effective right of remedy, not only for individuals, but for society in general, and for civil society organizations to better represent you. Think of the practice, not only of the law.
Yeah, I'd say the admissibility criteria for a complaint in Belgium are fairly low, so go out and try to file a complaint like yourself in case you're interested. It might lead to very interesting results and papers and all sort of collaboration like this one. So it's really, I would say, very interesting.
I'm sorry, it won't be a takeaway for you, but for me, if you hear of an administration that's comparable to Perrin, please let me know. We're looking for partners.
These were great takeaways. I would like to add, please focus on cooperation for NHRIs and equality bodies, access to documentation, cooperation with the future regulators is crucial for us to build cases. So thank you so much, distinguished panel. Thank you, audience. See you later.